Good afternoon and welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Well, I just suffered through a reading of Governor Wolf's motion to stay, Judge Stickman's order declaring the governor's business closure and stay-at-home orders unconstitutional, and the governor's corresponding brief in support. Reading the governor's motion in brief is like reading the book Chicken Little. The sky is falling, the sky is falling, but the sky never falls. As you know, Judge Stickman's order struck down the congregate gathering limitations of no more than 25 persons indoor and no more than 250 persons outdoors that were a part of Governor Wolf and Secretary Levine's various closure orders or COVID-19 restrictions. Now, the governor writes in his brief, if all congregate limits are abandoned, the virus will be free to spread like wildfire throughout the Commonwealth, resulting in an increased rate of infection and increased death. This harm cannot be undone. That's your governor. Where does the governor support this grand hyperbole and sensationalism of his? Nowhere. Repeatedly, throughout his brief, he brings up these super spreading events or mega spreading events and how they're driving the spread of COVID-19 and that they result directly from these large gatherings. And that by lifting the congregate limitation ban, the Judge Stickman, is killing people. That's the governor's brief. This is utter nonsense. If that is true, why did the governor and Secretary of Health agree that 20,000 people may attend the Carlisle Car Show? Is it because they were sued by the owners of the Carlisle Car Show and the owners were poised to win their case, so the governor and the secretary settled? Does that mean we all have to sue the governor to get him to back off his irrational orders? Also, the trial in the case presided over by Judge Stickman in the federal court in the Western District out there in Pittsburgh, the trial is over. The governor had every opportunity to present scientific and medical experts to support his case, his claim that lifting these restrictions will kill Pennsylvanians. Now, how many medical experts did the governor present at trial? Answer, 0. How many scientific experts did the governor present at trial? Answer, 0. Well, whom did the governor have testify in support of his sensational and hyperbolic claims that Pennsylvanians are going to die if we lift the ban and allow large group gatherings? Whom did the governor have testify at trial? His political and policy advisors and his administrative assistants, none of whom were or have any medical or scientific credentials. Although they may have studied political science in college, they did not study, let alone graduate with, or become certified or actual experts in something we call actual science. During trial, the plaintiff's attorneys cross-examined one of the governor's non-medical, non-scientific, administrative staff members, his deputy chief of staff. The attorney asked the staffer, again, not a doctor, not a scientist, just a political guy who's an administrative staffer in the governor's office. These were the people, by the way, who developed these business closure orders, these stay-at-home orders, not scientists. The attorney on cross-examination at trial asked this man, well, did any of the large protests lead to any known mega-spreading event? The governor's staffers was unable to point to a single instance in which a large protest gathering or any large gathering outdoors resulted in a mega spreading event. And here's what the staffer, non-medical, non-scientist, said. He said, I am not aware specifically, I have not seen any sort of press coverage or, CDC information about that. I have not seen information linking a spread to a protest. End quote, from the staffer being cross-examined by the plaintiff's attorneys in the County of Butler case. So that's it. Case closed. And I love how the staffer says he hasn't seen any news articles on it. And that shows you this governor rules by what he reads, or perhaps more accurately, by what his staffers read in the newspapers. If it's not in the newspaper, it must not have happened. That's the way these people think, these people who are running this government of the Commonwealth of Pennsylvania. The governor imposed the congregate gathering limits because he was concerned that large group gatherings would become mega spreading events. We've had many large group gatherings since then. I attended and spoke at several of them. And after the events concluded, the governor has produced absolutely zero evidence that they became mega spreading events or spread even one or had even one spreading event as a result. In his brief, the governor now tries to cite two newspaper stories again in the New York Times and CNN. Again, this governor rules by what he reads in the papers. And sorry, newspaper articles are not evidence. The governor had his chance to present his evidence at trial. He presented nothing. No medical, no scientific. And he didn't even cite the newspaper articles in the trial. His staffer couldn't think of any that supported their position that imposed this congregate gathering limit on 12.8 million Pennsylvanians. In his request for a stay, the governor makes a big to-do about two of my cases, William Benner et al. Versus Governor Wolf et al. The governor claims the losses we have sustained, and the other case was Friends of Danny DeVito et al. Versus Governor Wolf et al. And the governor claims the losses we sustained in those two cases creates a split in authority, and as such, that presents grounds in favor of granting the stay. He's wrong. In my Benner case, the governor only won a very preliminary round when the judge presiding denied our temporary restraining order request. There was no hearing. There was no evidence presented. It was just me and the governor's attorneys arguing what we put in the pleadings, and the governor's attorneys talking about newspaper articles and such. No evidence, no science. It was too early for an evidentiary hearing in that case. That will come later. The case is still pending, by the way. The judge has not ruled on the full merits of the case. In the County of Butler case, Judge Stickman, he had the benefit of a full trial with witnesses and evidence in which the governor failed miserably. The governor offered no experts, just opinion testimony from his non-medical, non-scientist, political, and policy advisors. In my Friends of Danny DeVito case, the Pennsylvania Supreme Court did rule against us on the business closure order, which, by the way, was the only order before that court at that time. And it did rule against us on federal constitutional law grounds, among others. But in the County of Butler case, federal Judge Stickman based his decision on federal constitutional law. And importantly, as a federal court, he is not bound by the Pennsylvania Supreme Court's rulings on U.S. constitutional law. And he's not bound by the Pennsylvania Supreme Court's decision in the DeVito case. And in the DeVito case, like the preliminary motion, the motion for a temporary restraining order that was heard in the Benner case, those were all decided without a hearing and without evidence. And by the way, the DeVito case is also pending on a request for an appeal before the United States Supreme Court. In the DeVito case, only challenged the business closure order, not the stay-at-home order and not subsequent orders, because they came after we filed and briefed and after the case was decided. Now, in order for Judge Stickman to grant the stay request, he must rule, number one, the governor will likely prevail on the merits of his appeal. Number two, the governor will suffer irreparable harm if the stay is denied. Now, by the governor, the courts mean the people of Pennsylvania, who are allegedly represented by the governor. Number three, that the plaintiffs, which includes basically all of the people of Pennsylvania who are subject to the congregate gathering limitation order, will not be substantially harmed if the stay is granted and the limitations are reimposed. And number four, that the public interest will be served by granting the stay and reimposing the congregate gathering limits. Now, the judge has already ruled, and this motion to stay went right back to Judge Stickman, as that's required to be. The judge has already ruled on the merits, so that makes it difficult for him to agree that the governor is likely to prevail on the merits. So the governor should lose factor one of this four-factor test. Factor two, the governor did not show at trial any mega spread as a result of the large gathering. So it's unlikely the judge will find the people of Pennsylvania will suffer irreparable harm if the stay is denied and the limits continue to be lifted. Factor number three, the plaintiffs and the people of Pennsylvania will be subject to substantial harm in the loss of their constitutional rights again to gather if the stay is granted and the limits are reimposed. So the governor should lose this factor as well. And regarding the fourth factor, the public interest factor, the public interest being served by granting the stay, that should go against the governor as well, because the governor failed to present any evidence that the public was being harmed by the existence of large group gatherings. Again, all of those large protests, the governor presented zero evidence that they caused mega spreads, super spreads, and zero evidence that they caused even one spread of COVID-19. That's simply the evidence or the complete lack thereof that was presented by the governor and the Attorney General of Pennsylvania in the trial presided over by Judge Stickman. Courts should not and cannot rule based upon hyperbole, emotion, fear, sensationalism that comes out of the mouths and minds and hearts of staffers, newspaper articles, CNN, New York Times. That's not evidence. That's not law. This motion to stay should be dismissed summarily. Well, that's about all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.